And I'd like to start with a Pledge of Allegiance, so if we could all rise. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I'd like to inform everyone that if you would like to address us during the public comment section, that there are request to speak forms outside that you can fill out and give to me. I'd also like to note that we have a court reporter today, Mary, and she has requested that we each speak one at a time, as we're accustomed to doing, so that she can be sure to take an accurate record. And if I could now begin with the roll call. Vice Chair Freeman.
Here.
Vice Chair Herrera.
Here.
Commissioner McNulty. Here. Commissioner Sturts.
Here.
We have a quorum. I'd like to recognize as well that Assistant Attorney General Chris Munns is over here, and he's acting as counsel today for us. Jim Barton is on a business trip, so couldn't make it. But Chris is from the Solicitor General's Division, same area as Jim. So thanks for joining us, Chris. This brings us to item 2 of the agenda, the minutes. So some revised meeting minutes from the February 24th meeting were distributed. Did everyone have a chance to review those? Yes.
Madam Chairman, I had one change. On page 2, third paragraph from the bottom, I think this was a change I noticed last time. It didn't make its way in. I believe it's Mr. Sturts asked that question.
Okay.
That was the only change I had.
Would you mind repeating that, just because I just found it?
Sure. The second page, third paragraph from the bottom that begins, Mr. Freeman asked why Miss Lanning. Sturts.
Okay. Any other corrections?
I think I had 1 or 2. I just need to find them here. In paragraph 4 on page 1, Secretary Bennett explained that 5 candidates. I thought we should clarify for the independent position will be interviewed.
Okay.
That's the only thing.
Any other corrections? Without objection, then, if we could go ahead and approve these minutes as amended, based on these 2 amendments that were just noted.
Make a motion to approve the meeting minutes for February 24th and March 9th as amended.
Second.
All in favor?
Aye.
Any opposed? Okay, these minutes pass as amended. And then we have another set of minutes from the March 9th meeting. And those were distributed. Did everyone have a chance to review them? Any corrections to those minutes?
Madam Chair, I was concerned that those minutes might, in a number of respects, not be entirely in sync with our transcript, and wondered if we should review them once we received a copy of the transcript. I don't see anything that's wholly inconsistent, but I do see some things that probably need to be clarified that we could do with the benefit of the transcript.
No, I would need to amend my motion because I included the March 9th meeting minutes.
Oh, that's right, you did. Yeah.
So-
Thank you for noticing that. So your motion is amended to just include
The February
24th
24th
minutes.
meeting minutes, the amended.
Right, because we're discussing the March 9th minutes now. Thank you. If I could ask counsel on that, if we do have a transcript of the March 9th meeting,
Right.
and so would it be appropriate to send that out to everyone for approval, and that would take the place of the March 9th minutes, or how does that get addressed?
Well,
the open meeting law doesn't really require that you approve them, and given that it's a transcript from a court reporter, I don't think the board would have to, the commission would have to review, a 100-page transcript and actually vote on it. You could rely on the court reporter to make an accurate copy, and counsel and the executive director will be able to look at it and make sure that there's no typos or anything. So if you want to substitute the transcript instead of written minutes, that'll work fine because it accurately represents everything that was said.
Right,
by
they're
every person.
more accurate than the
Right.
minutes, so, great.
Madam Chair, I would move that we substitute the transcript for the minutes of that meeting.
Do I hear a second to that motion?
I second that.
Okay. Any discussion?
Yeah. I have some concerns about just not approving transcripts. I would prefer the transcript, and if we can just go with the transcript instead of minutes, and that satisfies the open meeting law, I'm fine with that. But I am always used to reviewing transcripts and approving them before they become a final and official transcripts. Certainly in terms of context of litigation, the person who is being deposed always has that opportunity at least to review and double-check the transcript. And I know it means somebody has to read them. I'm happy to read them.
And actually, Madam Chair, all of the commissioners will receive a copy of the transcript so they can review it and send any changes to the executive director so that it'll be an accurate transcript. Sorry, I didn't mention that.
No problem. Counsel, is there also some kind of rule that we need to have the transcript posted within a certain amount of time at the end of the meeting?
Since they're your minutes, they'll need to be available within 3 days after your meeting. So you can check to see how fast the transcript will be available, and perhaps you may want to record a meeting as a backup so the recording can be available till the transcript is finalized, something like that.
Okay. Great, so we need to vote on that motion, I believe. Any other discussion before we vote?
Well, is the motion that we just simply adopt the unofficial transcript as our minutes of the last commission hearing?
Subject to an opportunity of the commissioners to review and clarify or correct.
If that's the motion, then
Okay.
I have nothing further to say.
Okay, any other discussion?
Could you restate the motion?
I would move that we substitute the transcript of the March 9th meeting for the draft minutes that were taken and allow the commissioners an opportunity to review the transcript upon receipt and make any comments and corrections.
Okay. All in favor?
Aye.
Aye.
Any opposed? Okay, so the motion carries. So we are at item 3 now on the agenda. And that's the call for public comment. I have 2 requests up here to speak.
Third one?
Oh, great, the third. Thank you. Great, so we'll start with Manny Bustamante. He is counsel at the Hispanic Center for Constitutional Law. Manny? Good afternoon. Good afternoon. Yeah, that would be great.
Thank you.
I hope it's mic'd.
Well, fine.
Might be. Yeah,
Yep.
good.
Is it okay if I sit?
Sure.
Okay, thank you. Good afternoon, members of the commission. My name is Manny Bustamante. I'm here on behalf of the Hispanic Center for Constitutional Law, and I want to thank you for serving on this commission. The service you're going to be performing as volunteers on behalf of the people of Arizona is a very important one. I want the commission to know I'm going to be available to assist the commission during this redistricting process. I wish to have an ongoing dialogue with this commission, and I look forward to working with the commission during this process. I know there's many issues the commission is going to face over the next several months, and today's meeting is more administrative in nature. However, what I'm going to speak to the commission about today will become your chief concern as commissioners, and that's going to be your ability to draw legal and fair maps. What's going to affect that ability to draw those legal and fair maps is the Voting Rights Act, and the commission must, in accordance with the Supremacy Clause of the Constitution, give priority consideration to the Federal Voting Rights Act, including both Section 2 and Section 5. Section 5 of the Voting Rights Act protects minority voters from any election procedures, including this redistricting, that retrogress or harm the interests of minority voters with respect to the benchmark plans. In our case, Section 5 prohibits any redistricting plan that harms minority voting strength. Therefore, Section 5 prohibits this commission from any redistricting plan that dilutes or negatively affects Hispanic citizens' voting interest. In addition, we're going to ask the Commission to pay attention to the requirements of Section 2 of the Voting Rights Act in light of the Supreme Court's decision in Bartlett v. Strickland. As the Supreme Court stated in that case, much remains to be done to ensure that citizens of all races have equal opportunity to share and participate in our democratic processes and traditions, and Section 2 must be interpreted to ensure that continued progress continues. I'm available to work with this Commission throughout this redistricting process to ensure that the voting rights of Hispanic citizens and all minorities are protected during this process. Our group wants to work with this Commission to ensure that there's no retrogression of Hispanic citizens' voting interests and no retrogression of any kind in the Hispanic majority districts. The United States Supreme Court stated that for equal protection of our citizens, we needed to have one person, one vote. The Supreme Court stated that we cannot create districts where voters have unequal voices. Hispanic citizens and all minorities have fought long and hard for the right to vote and have their vote heard in our country. Hispanics have a right to be heard and have their vote count. Under the Voting Rights Act, Hispanic citizens have a right to elect a representative of choice where the requirements of the Constitution and the Voting Rights Act are met. Arizona currently has 2 majority-minority Hispanic districts, and this Commission cannot permit those 2 Hispanic districts to become diluted. To ensure that Hispanic voting interests are protected under Section 5 of the Voting Rights Act, this Commission will need to use citizen voting age population in the redistricting process. This Commission cannot ensure that a district will be a majority-minority citizen voting age population district if the Commission does not create a district that has sufficient Hispanic population to ensure that Hispanics are a majority of the citizens in that district. If this Commission does not ensure that districts have a majority population of Hispanic citizens of voting age, then the result will be those majority Hispanic voting age districts will likely fail to be able to elect a candidate of choice because their vote will be overwhelmed by the majority of citizens of voting age. As this Commission is aware, Arizona is a pre-clearance state, and the redistricting plan will need pre-clearance before it can be approved. Therefore, this Commission will need to ensure that any new plan does not violate Section 5 in any way. I want to work with this Commission to ensure that any redistricting plan created complies with the Voting Rights Act and protects the voting interests of Hispanics. Thank you.
Thank you. Our next speaker, David Brown. And the subject, it looks like, is items 7 and 9 on today's agenda.
Good afternoon, members of the Commission. My name is A. David Braun. I'm an attorney, and just for your background, 10 years ago, I represented a number of plaintiffs in reference to the congressional aspect of redistricting. Seems interesting that we're meeting at the Board of Medical Examiners and we can find out where all the bodies are buried, maybe. Anyway, I want to talk about items 7 and 9. In reference to item 7, the appointment of outside counsel, I noticed that currently you have the Attorney General's office representing you, which was in fact the procedure 10 years ago. The first commission deliberately made this sort of decision in reference to whether to continue to retain the Attorney General or whether to go to outside counsel. The Arizona Supreme Court has given you some guidance in reference to your function during this whole process. And they've decided very specifically that the commission is not an administrative agency of the state, nor is it certainly a judicial body. It is equivalent to a legislative process. And you're subject to, of course, all the lobbying that legislators receive, all the emails and phone calls and contacts and the things that you've probably already gotten in reference to this process. And you're going to receive a lot more. I think it's essential in making a decision as to whether to continue to retain the Attorney General or to appoint outside counsel to consider certain factors. And notwithstanding the affability or the competence or the perceived neutrality of the Attorney General, the individual that may be assigned to represent the Commission, there's a real inherent conflict of interest. I've already written to Commissioner Herrera and Commissioner McNulty in reference to my concerns about that conflict of interest. You are partisan appointees, even though you certainly have to work together as one commission to ultimately come up with appropriate and legal maps that will survive your own evaluations and the Justice Department's evaluation and ultimately the court's evaluations, because almost invariably there will be litigation, and you should expect that and not be surprised or upset when it comes, because there's always going to be some politician or some group or some party or city or county that's upset with the redistricting map that you've drawn. Anyway, on that basis, I think you need to have outside counsel equivalent to what our legislature has. They have a Democratic Democratic counsel and a Republican counsel in the legislature, because I can't see among the five of you being solely represented by the Attorney General having I don't see how the Attorney General, rather, can represent all five of you with varying interests in this matter. I think the lawyers will recognize, the two lawyers that are already members of the commission, that there is going to be an inherent conflict of interest, at least from my perception, if the Attorney General is trying to represent two Democrats, two Republicans in this ultimately political process that you're entering. So that is my pitch in reference to item 7. In reference to item 9, which may not get very much attention, it may not be controversial, but it's just something that I have noticed. Currently, the website for the commission is, of course, the old website with all the maps and details and information from the 2001 process. I hope you retain that forever. It is a major historical piece of reference. Don't give it to the archives yet. Keep it as an available resource for you to use. If you have the time and energy, going through it will give you an idea of what the commission did 10 years ago and the struggles that they were having. You're going to have the same sort of struggles. I can see the Hopis and the Navajos coming to you and having a conflict. You've already had the first gentleman who spoke concerning the voting rights issue. The same sort of legal issues and political issues that were present 10 years ago are present currently. So that's my pitch for history and the use of those documents that you may find useful during the current process. And I thank you for your attention. Good luck.
Thank you. We have one more member from the public, Marcia Bushing, and she's Executive Director, and you'll have to say where.
Executive.
It says, oh, you're going to talk about the Executive Director
Yes.
position. I'm
Yes.
sorry. You're from, but if you could say who you represent.
I don't represent anybody other than myself, and I am Marcia Bushing, and thank you, each of you, for serving on the commission. And before I start talking about that, I just want to echo what David said about the website. It is very helpful, and it would be a shame to take it down, because I think not only each of you will find it useful as you go forward, but I think members of the public may find it very useful as well. But off that subject and onto the executive director, I missed the meeting in Tucson, so you obviously have geared up a lot more since the meeting where, Madam Chairman, you were chosen, and there's staff and audiovisual. But I think it's really important that you, in fact, continue the audiovisual. And what I came here in part to say as to the executive director is if part of your requirements or qualifications for the executive director would include somebody that has AV understanding and training, it might be very helpful if you don't otherwise have a full-time AV person to help you out. And in particular, I know one of the issues is budgets this year, and in mediations and arbitrations, I have conducted long-distance audio-visual as easy as doing 2 webcams, a Skype, and a screen. Skype on computer and screen. So you can, install Skype for free. The webcams are less than $100 a piece, and the screen can either be the wall or a screen. So you can set up remote access from all parts of the state pretty easily, particularly if one or more of you can't attend a meeting, and just have it that way. And I know that from other experiences, the web-based services for anybody viewing the meetings these days has gotten a lot cheaper, and it would be very helpful for members of the public, regardless of where you decide your offices are going to be able to view the meetings contemporaneously. Thank you.
Thank you.
Thank you.
Okay, that ends the public comments period. Item 4 on the agenda is the introduction of Megan Darien, who is State Boards Administrator, and she's going to be on loan to us, to this commission, from the ADOA. She's standing in the back, and I'm very grateful to Megan for her help in getting us up and running. And there are a number of people from ADOA who are in this room and will also be speaking during this meeting at various points in the agenda. But I'd also like to give a sincere thank you to Bill Hernandez, who is also here today. Bill went to bat for us, understanding that we really were in need of an interim executive director until we could get an executive director on board. And I thank you, Bill. Sorry, yes, Bill.
Raise your hand.
You could stand up. Thank you.
Thank you, Bill.
We all appreciate that. So that takes us to item 5, which is probably why most everyone's here today, the open meeting law and Robert's Rule of Order training by the AG office, Christopher Munns.
Hello, Madam Chair, members of the commission. I have put 2 handouts at each spot for you. One is a handout I prepared on the open meeting law. It's a little more detailed than the presentation I'll be giving. And the other is a PowerPoint done by one of my colleagues on effectively running a meeting. I also have copies of those out in the foyer for the public if they're interested. I'll start with the open meeting law and then go quickly through the running the meeting. Some of these concepts might be familiar to some of you, so I hope you'll bear with me. And if you have any questions, please interrupt me at any time. I actually prefer doing Q&A better than just lecturing nonstop. So I'll start with the open meeting law. And this seems like it would be a very simple law. And succinctly stated, it just means that all meetings of any public body need to be public meetings, and any interested person can attend and listen. So it's kind of simple, but we got a whole bunch of law that goes along with that. This concept is reinforced for this commission because the Constitution imposes the same public access requirements on you and actually puts a lengthier notice period. The usual notice period is 24 hours for a public body. For the commission, it's 48 hours. So I think that shows some intention that this commission be very accessible to the public. In addition to just the availability of the body for the public to attend, the commission also has to provide notice and agendas for every meeting, and these have to have enough information that a reasonable person in the public could know what you're going to be talking about and deciding. Now, the purpose for these sunshine laws, like the open meeting law, is to protect the relationship of the public, between the public and its officials, to promote accountability of public officials to the constituents, And this also allows members of the public to come in and by seeing what's going on to be able to more meaningfully participate in public life. So those are kind of the three things that should always guide you in any sort of open meeting law quandary, because some areas of the open meeting law can get kind of vague, and so you might have to kind of use a gut feel sort of decision. And usually in that case, we advise to err on the side of being open to the public. So I'm going to kind of do this in a top 5 sort of things you need to know. It's sort of like Letterman, except not as funny and only half. So the first thing, probably one of the most important things you need to remember as commissioners, is not to talk about commission business outside of an open meeting with a quorum of your fellow commissioners. All discussions, deliberations, proposals for legal action with the quorum of the board need to happen at a commission meeting. So anything outside the meeting between a quorum violates the open meeting law. And for this commission, the quorum is 3 people. Also, the open meeting law can be circumvented by what we call splintering the quorum. That means one person talks to less than a quorum, but does so one at a time and then passes on information from one to the next. So you essentially achieve a quorum, just not all in the same place. That has also been held to be an open meeting law violation. I don't see that happening intentionally very much anymore. Most public servants are honorable and don't do that. But we do caution public officers that it can happen unintentionally a lot, because sometimes conversations just happen, and before you know it, something might have slipped out that someone told you, and you've unknowingly created a quorum of the commission. So we encourage commissioners not to talk to other commissioners outside of the meeting about commission business. We do that first because of what I just mentioned with the possibility of an unintentional violation. And second, our open meeting law enforcement team gets tons of complaints all the time about the public seeing people talking to each other outside the meeting, even if it's not a quorum. So it undermines public confidence. They think that there's a lot of backroom negotiation going on, and they're not getting full access. So we always encourage public officers, members of the commission, to be very sensitive to that and not to talk to other commissioners outside of a meeting. Now, I know I'm sensitive to the fact that sometimes there are conversations are necessary. It's an appointed political position. So keeping in mind my first encouragement, I would definitely keep it only to one person, and never try to talk to a third person about it. You just don't want to run that risk, even if you're intending to keep it compartmentalized. You never know when something might slip out. So that's one of the hardest things I've had to deal with public officers on, is trying to keep that, keep everything just for the meeting, and have all those discussions at that point. Now, there's been a change in law a couple years ago. I'm sure a lot of you remember, maybe Scottsdale had a training where they talked about what board members can say to the public, and it was very much, please don't talk to the public about any of your business. So the legislature actually changed the law on that. So now commissioners can speak to the public in other venues than in a commission meeting about positions on sort of commission-related business. You can talk to a press at a press conference, address a group of people, and even other commissioners can be in the audience, preferably not a quorum though. But there are 2 qualifiers on that. The opinion or discussion cannot be principally directed at or directly given to another member of the public body. So you can't have like a sham press conference just to have some communications. And the other one is there can't be a concerted plan to engage in collective deliberation or to take legal action. So that would be more kind of sort of sham proceedings to get proposals out there for other people to see. This is kind of a rapidly developing area of the law. It's brand new statute, and then when you put in things like Facebook or any sort of internet communications, there's all sorts of pitfalls there. So if you're going to be doing anything like this, I would encourage caution, as well as probably contacting whoever your legal counsel is going to be about that if you plan to do something, any sort of address outside of a commission meeting. Any questions on that point before I move on to the second one? Okay, so we've covered no talking outside of meetings about commission business. Okay, in meetings, you can only talk about things that are on the agenda. The staff and your counselors they will put together an agenda that covers, they'll tell you everything you'll be talking about. It also tells the public what you're going to be talking about and deciding. If there's something you want to be on the agenda, you should contact the executive director, and essentially the chair will put it on, or the executive director will put it on, so that the board can discuss it. Now, agenda items, as I mentioned before, they have to be specific enough so that people can tell what you're going to be discussing or deciding. That's another one of the main areas that our enforcement team sees a lot. You try to be as specific as possible. As you notice, when we put the lease spaces down on your agenda, we gave addresses so people know what's going to be talked about, instead of something like, office space discussion. It doesn't really give much information. Now, there's an interesting thing in the open meeting law that says you can talk about matters on the agenda or items related thereto. Sort of with the common theme of what I've been saying, we usually advise to keep the related to part very directly related to the agenda item. And if you see that your agenda item is kind of spun off into maybe another discussion, I usually use the example of like you're talking about office space and it turns into a budget discussion. Perhaps it'd be best to put the budget discussion on the agenda for the next meeting so you can have a full discussion about that with no worries about the open meeting law. So the best practice is just to try and stay, exactly on the agenda and very closely related thereto. Anything new that comes up, go ahead and put it on the next agenda for a more full discussion. It also allows staff time to get you any additional information you may need on that discussion as well. So the third point is be familiar with executive sessions, how and when to use them. An executive session is the one exception to the open meeting law, essentially. It allows the commission to meet and discuss in private without the public present. It's very limited and very strictly interpreted by the courts. There's 7 areas where it can occur. I've got those listed in the handout I gave to you. It needs to be on the agenda that an executive session is possible for that item, for pretty much everyone except for legal advice and confidential documents, which, being kind of the nature of what they are, it's unforeseeable sometimes that those might pop up and the commission might need to go into executive session to get legal advice or to review some confidential documents it wasn't aware that would be introduced. What happens is a commissioner will need to make a motion to go into executive session and state the reason for the executive session, whether it's for legal advice, to discuss personnel matters, things like that. And then there needs to be a vote, a second and a vote on that. At that point, it's become a private meeting, and so the public will either need to be escorted out of the meeting room, and we usually recommend they take everything with them, just to be sure there's no recorders or anything you might not be aware of. It's a little paranoid, I know, but you need to be sure that it is private, because these executive sessions are protected by law. Every discussion in there is confidential, and you can be enforced through state law. Or you could retreat into a boardroom. This meeting room actually has a confidential boardroom right next door, so you can go there and the public can stay here and chat while you're in executive session. So everything in executive session is confidential and can't be discussed or released outside of the executive session. There are several sort of authorizations in statute for other people to get it. Board members who weren't present at the meeting can access the executive session or commissioners, because they're going to need to know what was going on with the commission even though they were absent. The Attorney General can have access to investigate open meeting law issues, and courts can have access to also investigate open meeting law issues, and the county attorneys as well. When you're in executive session, you need to sort of be mindful the whole time. I'm very uncomfortable every second I'm in it because of how narrowly it's construed. There's no final action or voting in executive session. So that means not even a vote to leave executive session. The chair would just adjourn and resume the open session. It's a common mistake I see. You need to make sure you stay on point with the reason why you're in executive session. So if you're in there for legal advice, you can't sort of talk about something else. Oh, we're in here, let's talk about the personnel matters we also have on the agenda. You need to stick with just the legal advice on the item you went in on. And also with legal advice, there's no discussion between the commissioners. It's just a discussion between the counsel for the commission and individual commissioners. Everyone can hear it, but the discussion about how to apply legal advice needs to happen in open session. So you can ask enough questions so you're clear as to what the legal advice is, but then how you're going to proceed with that legal advice, that discussion needs to happen out back in open session. With no votes or anything like that, there can't be any straw votes or any sort of consensus gathering while you're in executive session. That's a common temptation, especially in the legal advice executive session, since you're all in there. There are a couple of them that do allow for some discussion while you're in executive session, and so your counsel who will be in there with you can tell you about that. Personnel context allows for some discussion, and several of the executive sessions allow for instruction to your attorneys or representatives. So that would be in the case of settlement of litigation or negotiation of a lease. You may want to have more of a free-flow discussion between yourselves and your representative as to what sort of your preferred lease rate would be or your settlement options. And in the case of personnel, you may be talking about salary or discipline or which executive director you'd like to appoint, that kind of thing. So those are kind of the exceptions to the discussion rule, but still no voting and no straw votes. Also, the open meeting law does require minutes for executive sessions. I usually recommend that the executive session be recorded for maximum security for the commission. I say that because the way courts have structured the open meeting law challenges, the burden of proof is on the complainant to say that something happened in executive session that's not lawful. If it's a colorable claim, essentially, that something could have happened, the burden actually shifts to the public body to prove that it did not violate the open meeting law. So if you kind of have a general summary of what happened in there, that might not be as persuasive as being able to say to the judge, look, here's an audio recording of our entire open executive session. We were entirely compliant the whole time, and then the case is done. Whereas if you're going to be arguing about sort of a summary of what happened, that could drag out a little longer. So I usually recommend recording them and then keeping those secured. The minutes of the executive session are just as confidential as anything else, so they need to be separately kept from the regular minutes and secured. I usually encourage board members and commission members to work with each other to stay in compliance. So usually the lawyer's in there kind of nagging you and telling you not to talk about this, not to talk about that, but to the extent that you can also do it amongst yourselves, it helps, and not everyone will hate the lawyer for doing it. So are there any questions about executive session? I know I kind of just briefly covered that. It's in more detail in your packets, especially like each ground for executive session and some of the quirks that go with that. No questions? Okay. Number 4 is call to the public's. Calls to the public are for listening, not talking. You guys already did the call to the public, and you did great on it. Essentially, it's just a time for members of the public to address the commission on any item that's within the commission's jurisdiction. Even if that item's not on the agenda, the public can bring it to your attention. Now, what the commission members can do is more restricted. You cannot engage or discuss the matter with the public member who's addressing you. You can direct staff to investigate the matter, or you can have staff put it on an agenda for future discussion. There is an exception to that. The open meeting law does allow the commission to respond to criticism. We advise to keep that very general and very short. I can't even really think of any good. I do see it happen very often, but usually if it's important enough that someone's complaining about it, it's probably important enough to put it on an agenda so you can have a full discussion about it instead of trying to be very short and general in your response. It's kind of a short topic, but it's pretty important. Any questions on calls to the public? Okay. In the last topic, in my top 5 things to be careful of is be careful using emails in your communication with other commission members. This one, it gets a lot of people in trouble because it's so easy to do. Emails among a quorum of members talking about commission business are violations of the open meeting law, just like it would be if you called everybody or if you kind of met up for a drink after work or something. It'd be just as bad. So our best practice advice is not to email other commission members about commission business. Save it all for the meeting. Use staff to kind of communicate about that stuff. If you want to put something on the agenda, if you found some information that you think the rest of the commissioners should consider at the meeting before acting, that stuff's good to send to your executive director, who will then make sure it's disseminated and it minimizes any risk of unintentional open meeting law violations. I say that because the temptation is always to hit reply all, or maybe even mistakenly to hit reply all instead of reply when a board member, a commissioner sends out, like, I found this newspaper article that's relevant to what we'll be talking about next week. You might want to send that to a quorum of the commission, and then someone might reply all, saying, oh, that's really good, or something. So it's good just to avoid that by sending that article to the executive director, who will then include it in the commission packet or do a separate email out to everyone with that information. Just like with any other communication or phone call, serial sort of emails will violate the open meeting law, being one commissioner emails another, and then that email gets forwarded to a third. That's just as much an open meeting law violation as, sort of calling everyone up in sequence or passing along. To some degree, the emails, they are a little more complicated, but they're still basically just another form of communication, so a lot of the same rules apply. I've talked to you about reply all, and we do advise just never hit that. If we could just disable that button on sort of public accounts, that would be awesome, but we can't do that. We actually do have an attorney general opinion out about email communications, and I can send that to anyone if they're interested. It actually has some helpful examples on page 9 where it goes through a number of common situations that board members find themselves in, whether it's receiving letters from the public that you want the rest of the commission to see, coming across information you'd like to share with the rest of the commission, that kind of stuff. So just let me know. I can send that out, or I can send it to Megan, who would be able to send it to you as well. That's pretty much all I had on the open meeting law. If there's any questions, I kind of kept it to the things that would be most of concern to you, and not some of the technical nuts and bolts about posting notices and agendas and that kind of stuff. If there's no questions, I'll move on how to run a meeting. How am I doing on time? Okay.
I actually have a question.
Okay.
Chris, I'm curious to know, and we don't have to address it today, but at some point, if you can send me information on just running telephonic meetings and any special rules surrounding that, and how, if we can vote and things like that electronically.
Actually, the commission can have a telephonic meeting. You just have to make sure it's noticed, and it's on the notice in the agenda that it'll be telephonic. You'll still need to have a public space where the public can come and listen to all the discussions and deliberations. And you can vote and you can do everything just like a normal meeting. It's just that there's a couple extra notice requirements on that, and then the space requirements.
Great, thank you.
Okay, so how to run a meeting. I've given everyone a sort of PowerPoint that goes over this. Essentially, everyone relies on Robert's rules. And the question is, why even use those? It seems you go to some of these meetings, and they seem very stilted and overly formal, Mr. Chair, all this stuff. But the way it works is it promotes efficiency by organizing everyone speaking so that no one's speaking over each other. There's a way of telling who's going to speak first and make sure that there's not confusion and too many people trying to talk at the same time. It also promotes fairness by allowing everyone to be able to express their own thoughts on a matter before the commission acts on it. The way the process is built up as it encourages discussion before a final vote on a matter. And finally, it kind of provides legitimacy and familiarity. This is the generally accepted process for doing sort of multi-member decision makers. So there's a kind of a familiarity from people who've never even been on a board, but who've seen a lot. They kind of know how things are going to work from board to board. Even if you've never been on the commission before, and you were on, let's say, the Behavioral Health Board, you kind of know how the process works. And the other thing, it does kind of lend some legitimacy because you're using a generally accepted rule of procedure and it gives you a little bit of ability to forecast how things will shake out. Because the Roberts Rules of Order, in their purest sense, conflict with various provisions of the open meeting law and other state laws, we have to use a modified version of it. So it's not a strict application of the Roberts Rules. They're the Roberts Rules are very detailed. They have priority of motions. Certain things can be discussed before other things. Votes have to be taken on certain motions before other motions. So a lot of that stuff, a lot of public bodies don't use. They kind of use the general guidance of the Roberts Rules of Order, but not the specifics. And there's some flexibility for the commission to decide how formal it wants to be on some of these rules. We always encourage, at least at the minimum, to try and maintain a sort of professional appearance and use, instead of kind of familiar first names, use Mr. Jones or Mr. So it's a very professional kind of setting. Now, the role of the chair under Robert's Rules is basically to run the meeting, to be in charge. She will recognize the speakers and make sure everyone gets to speak in turn and make sure no one's talking over other people. That helps keep the record clear, as Mary asked us to do. And it also helps keep the sort of the procedures moving. And so part of her job will make sure that kind of bringing an end to kind of fruitless arguments or to make sure that to try to build compromise or whatever is necessary to kind of make sure the commission gets its job done. The chair also helps keep the record clear by restating motions and announcing the results of votes. She'll also be stopping side conversations. I see this happen in a lot of public bodies. Side conversations that aren't intelligible to the public actually violate the open meeting law if they're about commission business, because it's a discussion about official business that they can't hear, which violates one of the primary tenets of the open meeting law, that they be able to hear everything. A lot of times I know the side conversations are about personal matters or whether we can take a break or something, but I would still encourage the commission to speak up about that if it's a break, be forthright with that, because once again, the perception from the public is perhaps you're talking about official business that you don't want the rest of the public to hear. So we get a lot of complaints about that as well. And usually it turns out that it's just one board member asking for a bathroom break, unfortunately, but it results in a complaint to the AG's office and press and all of that. So we try to keep sided conversations to a minimum, if any at all. Also, the chair is responsible for preventing disruptions from the public. A disruptive public member can be asked to leave after several warnings, highlighting the disruptive behavior and asking them to correct themselves. So usually it needs to be pretty egregious, like speaking out, yelling, or something like that before that can happen. And I'd probably encourage you to speak to your counsel before exercising that authority. Also, throughout the rest of this presentation, there's going to be suggested language in your handouts for motions and the like, so I won't be going through that. As you can see, when you start the meeting, usually the chair will announce the name of the body, the date and time of the meeting, and then have a roll call to establish quorum and attendance in your minutes. The chair can also, in the discretion of the commission, have commissioners introduce themselves so that people know what their role is on the commission, and have staff and council introduce themselves as well. What the commission cannot do is have members of the public identify themselves. The only time you can ask a public person to identify themselves is if they're going to address the commission, and because the open meeting law requires that the minutes have the name of everyone who addresses the commission. So after you get through the start of the meeting, the order of business is basically defined by the agenda, as I've told you. You just go from item to item. You can take them out of order if you desire. It doesn't require a separate vote. And I'm just going to briefly go through the motion process, which is how you'll resolve most of the agenda items. The basic motion is I move that the commission do X, there be a second, usually discussion, and then the vote. The chair should make sure that there's only one motion on the table at a time, which sometimes can be confusing if it's sort of one of those issues where it gets a little bit heated and there's multiple motions coming out. So you should probably go with the first one, see if there's a second on that, and then resolve that one. The chair should repeat the motion so that it's clear on the record and clear for the other commissioners what people would be voting on, and then ask for a second. If there's a second usually that's when there'll be discussion. There's some flexibility on this. A lot of boards and commissions don't do it this way. There can be discussion before motions are made as well, because sometimes you'll have like 10 or 12 motions if you can't have a discussion as to what everyone's thinking. So I do encourage some commissions to have discussions amongst themselves about what they think about the appropriate action, and you can kind of see where the consensus is going, and it can minimize some of the motions being made. But the formal, if you're doing a more formal option, it would be you have to discuss after there's a motion and a second on the table. So that's kind of up to the commission how to do it. After there's been a motion, a second, and discussion, the chair will call for the vote. And a vote can be either a voice vote, essentially all in favor say aye, or it can be a roll call where there'll be a roll call and every person will say aye or nay or abstain after their name is called. The vote needs to be public and observable. We can't have any secret ballots or any form of voting that can't be seen by the public. I've seen the show of hands, which is, I guess is acceptable because it's observable, but the chair needs to be especially diligent to announce the result of the vote. Some chairs forget that, but usually after the vote is called, the chair should say motion passes or motion fails, so it's clear on the record, especially if you're doing a hand vote. If there's a tie vote, it means there's no action, so the commission has to deliberate further and put another motion on the table because no majority has been able to achieve a consensus. There's another option on voting, which is the unanimous consent vote, which I think the commission is familiar with, which is especially good for adjourning meetings. Basically works, the chair will say, if there's no objection, I will adjourn the meeting, and then wait a second, and hearing no objections, this meeting's adjourned. That kind of is how it works. But if someone objects, you would just go through the regular motion-making process.
I have a question on that.
Yes.
Can I just adjourn the meeting if it's an agenda item? Because I had been told that by a few people, and
I've allowed them to. I'm pretty sure Robert's rule strictly enforced would have a motion, but I don't see a problem with that because it's not really an official action of the commission or anything. So.
Okay, thank you.
Now, there's a couple special motions that come up a lot. First is kind of as modifying a motion, which is a motion's on the table, and there's been a second, but someone wants to sort of tweak it a little bit, and then everyone will be happy with it. So if that motion to modify is brought up before the chair repeats the motion, then the motion maker and the second can just agree to it, and it'll be fine. Then you can vote on the modified motion. But if the chair has already repeated the motion, saying I've got a motion and a second to do X, then the person who wants to modify it must make a motion to amend the original motion, and then that needs to be voted on before you vote on the original. So it just makes the record clear. So the chair has already said, I have a motion and a second to do X, and someone says, well, I move that we amend the motion to do Y. Since you've already repeated it, then the motion maker would say, I'm fine with that. Or no, I'm sorry, I'm going back. Then the commission would vote. If they vote it down, then you would vote on the original motion without amendment. If they vote to accept the amendment, then you can vote on the amended motion. So it's a little awkward, but that's why I encourage discussion before the motions start flying, because it cuts down on the amendments and everything. You kind of get a good feel for where everyone's at before the first motion's made. The other kind of special motion is to force a vote. Sometimes discussion will go on and on when you have a motion and a second on the table. And so you kind of just want to move forward. Sometimes the chair can call the vote, or a commissioner can call for the vote to cut off the discussion. That's actually another form of motion. You'll need a second. There's no discussion on the motion, and then there'll be a vote on whether to cut off discussion and go straight to a vote on the original motion. So that's sort of the other special motion I see a lot. I do see some boards just say call for the vote, and the chair will respect it and do that, and the rest of the board will do it. What I've told you is kind of best practice, but I don't think it's a huge violation if the commission, as a matter of course, respects a call for a vote from one of the commission members. And then finally, adjournment, which we've already discussed. The chair can just adjourn the meeting if there's no objection, or you can use the unanimous consent option, Or you can do the formal motion process. I move to adjourn second and then vote on it. The chair should note the time the meeting ends for the minutes, and then you're all done. You should probably make sure that, I recommend, because of the open meeting law considerations, not to have commissioners sort of hanging around talking about stuff afterwards, because it gives kind of an appearance that maybe the meeting's still going on, they just wanted the public to leave. And I've actually seen some boards do this unintentionally, where they forgot something at the meeting, and then everyone's still here, let's talk about it now, kind of thing. And so that would be an open meeting law violation. If it turns out you forgot something, just put it on the next agenda and deal with it. And when I say next agenda, it doesn't have to be a full month. You can have special meetings or whatever's convenient for the commission to deal with something. So all that's needed is the 48-hour notice period. So that's all I had on running a meeting. If you have any questions or anything.
I have a question. You mentioned the commissioner can call for the vote, that doesn't have to just be the chair. And you said that does have to be seconded if the commissioner calls?
That's the best practice.
Okay.
I've seen it done a little more informally, and that can be up to the commission.
Okay, thank you. Does that conclude the training?
Yes.
Oh.
If there are no questions.
Okay. Thank you very much, Chris. I appreciate the information. Got some homework to read all this. So that takes us to the next agenda item, which is discussion and possible action on the executive director position description and other administrative support. We all had some homework this time between meetings. At our last meeting, there was general consensus that everyone felt like the executive director position is the most important thing that we needed to get moving on. And so we decided that as a commission, we'd focus on that first. What we did is we worked with the HR division at ADOA, thanks to Ron Lloyd and Susan Lawrence. They've been very helpful to us in walking us through the process of how we do that. And Ron sent around a position description qualification for the ED position and asked us to each respond back to him with if we had any input. And he distributed today a document that is actually contains the input he received. So it's got the edits that he incorporated to that original draft. If I can find it myself. There you go. The page major responsibilities, which is the third page, is kind of the one that talks about the duties. And as it's been described to me, it's not. It doesn't have to be perfect, this position description qualification, in terms of the exact percentages of how much time this person's going to be spending in each of these areas. And we can adjust these primary responsibilities too as we need to. Once the person's hired and in the job and we determine they need to be doing more with the website or whatever it is, that we can incorporate that into it. So this is really just a way to get this going so that once the position description qualification is approved and finalized by us, then Susan Lawrence can take this and create the job description and then begin to do the posting, collect resumes, and all the things that we need to do to get somebody on board. So it's pretty important that we get this piece going, and I'm wondering if everyone had a chance to review it and if there's any input on what you see in front of you. So any commissioners have any?
Yeah, I don't, I just, Madam Chair, the changes that I think both you and Commissioner McNulty made I think were right on. I like it.
Okay. Great. Any other input?
Madam Chair, may we discuss the process subsequent to the release or the approval of this document?
Certainly.
What the process that I understand it to be would be that this would be then turned into a posting of a job description.
My understanding is a position description first that Susan Lawrence then writes up based on the position description qualification. And then she then moves forward, and she's not here today, but she has a colleague, Jackie Mass, here if we need to get into detail on the process that they'll need to undergo. But my understanding is that once that job description is written based on this position description qualification, she begins to post it and then collect resumes for us. And actually, she's also acting as the person, the receptor, so to speak, of any expressions of interest that we get from the public. So if anybody sends any of us an email or approaches us directly on interest in that position, we can direct them to her, and she will ensure that their interest is noticed, and she can ensure that they're aware of when the position's posted.
And I'm sure after the collection, after the deadline has been met and the collection of the potential applicants are made, what is the process for vetting?
That is a question that I would ask Ron Lloyd about, and Ron's, or Jackie Mass, either one.
I'll probably take it. After the resumes have been collected, Susan will basically put them in groups, like high priority, met all qualifications, met some of the qualifications, met very few of the qualifications. She'll provide a spreadsheet for you. She'll send that in addition to all the resumes that you will receive. You will have a period of time to look those over. I don't know if you go back into open session or closed session then to determine which candidates that you would like to interview. She can set up the interviews for you. She can do the pre-screening for you. She can prepare all the interview questions for you. And you need to determine your timeline, because everything will have to be backed up toward that timeline. So if your objective is to have somebody on board within 2 months, then here's when you need to have the job posting done. Here's how long it'll take for the spreadsheet to be completed. And then you have to allow, in case you have anybody from out of town, you have to determine how long it'll be before you can fly those people in or do a conference call with them. And also you need to determine whether you're going to just utilize azstatejobs.gov website, which is our official website, or if you determine that you would like to advertise in another medium, as like a Career Builder or Monster newspaper.
And, go ahead.
So, Madam Chair, are those discussions that we want to have memorialized today?
I would like to, if possible, finalize the position description qualification, since that's the first step in the process, so that they can then begin to do their jobs to continue the process. But I don't, unless people would like to discuss specific candidates or something today, which I am not sure we're at that stage yet, but.
Madam Chair, I would not.
Okay.
I agree with you with finalizing the job description so we can move forward.
Okay. A clarifying question for Jackie, if I can. It's my understanding that there is no posting requirement in terms of it needs to be up. So there's no legal requirement, but it's just more of a nice to-do sort of thing that we'll post it for a period of time. And we'll be,
Correct.
okay, great. So there,
Minimum, usually what we do is 3 days.
Okay.
Maximum is until you've received enough adequate resumes. The process can be closed, so we just leave it open until filled.
okay. Thank you.
Madam Chair?
Yes.
I do have a question. I don't know if you can answer it. Once we decide on the people that we want to interview, are these interviews done in open meeting?
That's a great question. I don't have an answer. I don't know if council can answer that.
You can interview in executive session.
Thank you.
So, Madam Chair, if I understand correctly, we wouldn't need to establish the time right now that we were going to leave the application process open. We could just leave it open until,
You could.
or we
you
could
go to
determine
next-
now that we wanted to leave it open for 3 days or
Absolutely.
5 days or 10 days.
Typically, Susan can do everything from every day she can send you resumes and update the spreadsheet, or at the end of each week, she could do it. I think it really depends on your timeline, internal timeline, as far as how soon you need to have the executive position filled. So
From
that will dictate how quickly the process needs to go.
From the perspective of the Department of Administration, kind of backing out the amount of time we would need to interview and make the selection, how much time do you need between the date that we close acceptance of applications and the date of appointment?
Typically, what we would do is, again, if there's a sense of urgency, which I assume there is, we could send you every 2 to 3 days an updated list of the resumes, send the resumes out to you, and if you have a sufficient number that you feel is adequate, then we can close the posting off at that point, and then we would start the pre-screen process, make sure that they pass all the background verifications, and we would schedule interviews for them at your next executive session.
One more question. Once you receive our approval of the position description questionnaire, you take that and create the description and do the posting without any further approval from us?
No, we can absolutely send it to you, and you can look it over, see if there's any additions or corrections you want to make to it, get it back to us, and the minute that you approve it, it'll be posted that day.
I would ask Mr. Munns then whether we have to have a meeting in order to do that,
To approve?
to approve the position description that they draft based on what we might approve today. Do we have to have another, the 5 of us have to be together in a room again, or?
My understanding is if you submit this, approve this document, that's what they're going to be working up. You can rely on that. But if you have it sent back to you for more comments and additions that are going to have to be made to it, you'll have to approve that subsequent one as well. You can rely on them if you approve this as is. They're just going to translate this into a posting and not change anything.
Okay.
So you wouldn't need to approve anything because there
Okay.
would be no changes. If that's my understanding correct from DOA?
Yes,
Yeah.
whatever you want to do. If you want us to, once you've approved it today on the position description, we can get the posting ready. We'll have all the key factors in there, and we can just post it immediately if that's what you would prefer doing.
Commissioner Freeman?
And, thank you. Perhaps another question for council. If we decide we have sufficient resumes now, we want to pull the posting and proceed with the interview process, is pulling the posting an official act that's going to require us to meet?
Yeah, I believe it would be, because it would be an action of the commission to sort of close that period early.
So then perhaps what we need to decide is, are we going to leave it open for a week and a half, 2 weeks, and see what we have? If we don't have sufficient, we can reopen it, I suppose.
Good idea.
That's fine. Any other,
Madam Chair, I do have one question. The job description does not list a salary range or a grade level. Should it?
Ron gave us some information, background information on the salary range for that position. I've got it right here. Executive Director is grade E3, salary range $70,540 to $126,973.
So does that need to be in the?
In the position description qualification,
Correct.
no. Ron, would you like to address that?
No, Madam Chair, Commissioners, that does not have to be in the position description itself. That is a separate, it's depending on what the grade is, which is on the position description, the salary range is posted on our website, the Department of Administration HR website, so that can change, the salary can change sometimes, and so it's kind of a fluid document where it just relates to the grade, E3.
Thank you.
Any other questions or discussion about the position description?
Madam Chair, other than by name, where does the E3 grade show up on the PDQ that we're looking at currently?
I'm looking at that myself, see if I see.
If not, it would need to be added just for clarification. And secondly, while you're looking at that, I'm going to give a recommendation that to get the widest, because we are looking at a compressed time period, the widest array of advertisement would be preferred. to get out, because if, with a compressed time frame, we can't rely on a group of, a wider group going to a smaller location. So advertising on all resources that would be typical for this type of position would be preferred.
Okay. Any other thoughts? By the way, I did not see, Ron, where this is, the E3 is noted on the PDQ.
It is not, the salary range chart itself goes by the job code, which is posted at the top.
Okay.
So you would look, when you bring up the salary range, the job code is the first thing you would see. And on our website, and the job code indicates that that job is an E3 on the website, so it is not on this form.
Thank you. Okay. Mr. Herrera?
I'm okay with this. I think the ADOA knows what they're doing, and I have complete faith in them. But what I do want to do is for us to come up with a date of a week or whatever, so we don't have to meet again to close the whole application process. I would be comfortable with a week. I think the minimum is 3 days, so I think a total of 7 days would be sufficient.
7 days that it's posted?
A total of 7, correct, a full
Mhm.
week.
I have a question for council. If there is a commissioner that has an applicant in mind that may not be aware of the posting, is it appropriate for is there any issues at all with a commissioner contacting a potential applicant?
No, I might have to look into that one. Employment law is not my primary area, so.
I asked that question of
Yeah, I
council.
thought someone, did
Right.
you ask Jim that?
I did, and he confirmed that, wait, say your question again? I've lost my
She could-
train of thought. If
If a commissioner
contacts,
contacts someone that may or may not be aware
right,
that the posting is in place and the time frame has been set, is there any conflict?
no. Jim has told me that it is okay for us as commissioners, individual commissioners, to approach someone and let them know about the posting, or if we think they'd be qualified to go ahead and apply, or he said as long as you are doing a public posting, and, you're doing a public search as it is, it's okay to go ahead and approach people individually.
Thank you.
Madam Chair?
Yes.
We do have our interim ED, Megan Darian, who we could send the information to, who then she could probably send the information to the individual.
Yes.
Safe side.
Yeah, and actually Susan Lawrence in HR has volunteered to be that person, to the collecting focal point for any expressions of interest. So, in fact, I've received some, and I've forwarded them to her to let her know that this person is saying they're interested in the ED position, so that she can acknowledge receipt of their interest and then let them know as the process unfolds.
Could we have her contact information so we can, or do we?
Have her contact, I'm sorry?
So if I get a request, I can send it directly to her? Right now, I don't have any
Yes.
information on Susan's information.
Yes, oh, of course. I'll send out Susan's contact information to everybody and make sure you have it.
Madam Chairman, assuming we approve what we've put together right now, how quickly could it be posted? Could it be tomorrow?
Literally, and just to add to that, the salary range and the E3 will be on the job posting.
Sure.
So it will be obvious to the applicants what the position will pay. It will take us one day to complete the job posting. If you want to give us the authority to just post it, it'll be posted that day. And if you want to leave it for 1 week, then we will do that. If you want us to extend that 1 week because you're not getting sufficient applicant flow, we can extend it.
Okay?
Madam Chair,
Yes.
I assume perhaps that we will be meeting next week, and if we were, that we could either extend it or we could leave it open and close it next week.
Sure.
Either, I think, would work.
Yes, I think we're going to be having more frequency in our meetings, so we could easily do that. And I had a clarifying question for Mr. Herrera. You suggested 7 days. Is that 7 days or 7 working days, business days?
7 business day, probably,
Okay,
not
okay.
including Saturday and Sunday.
Okay.
And again, if you don't get enough applicants, we can always extend that.
Right. And there was one other thing about this. There is a hiring freeze with all state agencies, I'm presuming. And so we had to fill out a justification to fill form, and that's been done, and that's working through the process, and hopefully that will be approved very shortly, so. Okay. So, great discussion, everyone, and great questions. I'm wondering if I hear a motion to approve this position description questionnaire as distributed this morning by HR, so that we can move forward with the rest of the process in terms of hiring an executive director.
Madam Chair?
Yes.
I'd like to make a motion to approve the position description questionnaire for the executive director position as given to us by the ADOA.
Great. Do I hear a second?
Second.
Any discussion? All in favor?
Aye.
Any opposed? Great. Motion carries. This position description questionnaire stands as distributed, and we'll be working and moving forward with Susan Lawrence on the next steps. So thank you very much, Ron and Jackie, for your advice and guidance.
Madam Chair, before we leave
Oh,
this,
I'm sorry.
do we need to have a motion formalizing that we're going to leave it open until April 4th?
I think the first Monday of next week should be the first date, because they'll be needing at least a full day. So I'm assuming they'll need Friday, and not posting it Saturday and Sunday, and posting it on Monday, which is the 28th?
Right.
Yeah.
So till the 4th?
13th.
So that makes it,
6th would be 7 working days.
No, the 6th, you're right.
April 6th. Sure, then would someone like to motion that? Was that a motion?
Sure,
Scott?
I'll move that we leave the posting up until April 6th.
Okay. Do I hear a second?
Second.
Any discussion?
Yes, please. Could you clarify that the posting leaves it open with the assumption that that it's posted no later than Monday?
correct.
Correct.
Okay. And would you also accept the inclusion of that the posting be in not only on the State of Arizona site, but also in newspaper, Monster, and other applicable forms of advertisement that fall within the general purview of the Department of Administration?
I agree with that.
Any other?
I second that, yes.
Okay. So
And
is that
lastly-
an amended motion, or is that a new motion?
Yes.
He's actually
It's an
amended this
amended.
motion.
Okay, okay,
And she's accepted the amended motion.
okay, great. And you had another?
I want, would the maker of the motion also accept that we denote, because there have been multiple PDQs in distribution over the last 3 days, that we actually mark this document as an exhibit for the record?
I agree.
Okay.
Second as amended.
So do I need to restate that motion, the amended motion? The four amendments.
If it's clear to all the.
Clear to me.
So, well, I guess for my own clarification, I want to make sure I understand. So we're going to, we have a motion on the floor that's been seconded to leave this position posting open until it's Wednesday, April 6th.
Correct.
And
5 o'clock?
the 5, close of business. Good idea, close of business, Wednesday, April 6th.
With the assumption built in that the posting will begin no later than Monday.
Monday,
Yeah.
I think it's 28th.
28th. Thank you. And that we will also be posting this in a variety of sites that are normal for this level of position that we're seeking. And and I'm of the understanding HR can help us with those outside sites as well, right? Okay,
We'll do that.
wonderful. Oh, great.
Question?
Yes, please.
Do you want us to send you the resumes like every 2 days? Or do you want to wait until the 7-day period is over before we send you the spreadsheet and resumes?
I prefer to get them as I receive them,
Okay.
if possible,
And
as you receive them.
the position description was good as it's presented today, or did you have any other changes?
No, it's as, right, it's already approved, we're good. This is the final one. So we need to vote on that motion as amended. All in favor?
Aye.
Aye.
Any opposed? Great, the motion carries as amended.
Madam Chair, could I ask Mr. Munns a question?
Certainly.
So as we get the resumes, may we all receive them, or does that violate
Good question.
open meeting
You can
law?
all receive them, but you can't talk about them with each other. until
Thank
the
you.
meeting.
Should that then go perhaps to our interim executive director, those resumes, and she sends them to us, or is it okay for for Susan or Jackie to send them?
Probably best to go to your interim ED, so that way she can also keep track of who you're getting as well.
Okay.
Keep a master list.
So they'll go to Megan, and Megan will distribute to all of us. Great. Okay, we're moving right along here. Oh, actually, we're still on item 6, because there is the clause and other administrative support. And I wanted to see, we talked about possibly having a position where a person would maybe do outreach for us, as well as be kind of an IT expert to handle all this electronic outreach that we want to be doing as a commission. And Susan Lawrence did send me a couple position descriptions of other boards that have done this. Mostly they're web IT folk, if I could just characterize them that way, as opposed to, having necessarily all the outreach and communications advanced team type experience. But that is something that I just wanted to raise as a possible position description that we might want to create as a commission. Because even though we're focusing on the executive director position right now, that other staff is going to need to also get moving as well. We're going to need to hire other people to help that executive director. So just wanted to raise that as a thing to consider by the commission. As well as if there's any other position description qualifications that have been distributed that were from the previous commission. There's the executive assistant, the public information officer, any of those folks. If the commission would like to discuss any of those today, if there's any strong opinions or feelings about hiring those
Madam Chair?
people. Yes.
There was, I think, 3 other positions, correct, in addition to the executive director. You had mentioned the executive assistant, the public information officer, and then the third description, which I'm blanking on. I think it was the outreach person.
Right, they had, there was executive assistant, then an executive administrative secretary, a press secretary or public information officer, and a receptionist.
So that's 4.
Mm-hmm. Yes.
After reviewing the job description of the public information officer from last time, I really feel that the executive director we hire should have those qualifications. And I think they're included in the job description.
Right.
So I don't really see a need for a public information officer if we hire the right ED. But I do see a need for the other positions, including the community outreach person.
Okay. The public information officer, if I'm not mistaken, last time handled a lot of press inquiries too, and they were only engaged for about 1.5 years, is my understanding. So they weren't with the commission the whole time, but especially during the mapping and the work of the commission, they were utilized heavily to handle press and then also do some outreach with the public.
Madam Chair, I'm going to make the suggestion that we work diligently to get the PDQ outline underway for your AV tech folk, as you described it, quickly, because that is the development of that platform for communication with the general public is imperative for us to begin right out of the gates. And it's probably going to be as important as any administrative person that the ED is going to have on their staff.
Right. Okay, any other comments on
Madam
that?
Chair, if we could review the PDQs at the next meeting and approve them, that would be, I think, ideal.
Correct.
So,
Okay. And I believe, unless we're able to somehow shift the one that's already in the system, this, let me use the right term, this public information officer. I don't know if that can be expanded, so to speak, to have this web AV type responsibility, or if it really needs to be a new position that we would need to create. But we'll have to get some advice. Yeah, there's no way to.
Sorry, I couldn't hear all that.
Mhm.
Sorry.
I couldn't hear everything you said.
Okay, I'm sorry. Typically, the PIO position is very different from your web position. One's more of an IT position.
Right.
One is more of a communications position.
There is also already in the system a community outreach coordinator, and I wondered if that person maybe could be expanded, that role to include, if they have the IT and web background experience, that they could manage our website and other things. But we'll talk to HR about that and whether or not we need to create a new PDQ or not. But I appreciate your comments. Any other thoughts on these positions and the executive assistant or anything? One of the roles of the executive director is that they're going to be helping us in the hiring, and I'm sure they'll want to say in who they have supporting them on staff. So the sooner we have that person on board, the better. Okay. The next item on the agenda, item 7, discussion and possible action on request for proposal process for securing legal and consultative support. So while we discussed how the executive director position is a priority for us as a commission, there was general consensus last time that we also want to concurrently be moving forward on securing legal counsel and other consultative support. So given that, we've done a little bit of homework too on that front, where let me first just say that as for legal counsel, we have 3 options, and those have been discussed a little bit today. One is continuing on with Attorney General's office and their counsel. The second would be to utilize counsel that comes from the AG, the Attorney General contract list. It's an approved list that's already got all the counsel on there that for a variety of different services, and we can look through that and choose counsel that way. Or we can issue our own request for a proposal and go off the list, so to speak, and hire whoever we'd like. So those are the 3 options, but regardless of the option we choose, we have to get that statement of work or scope of work paragraph approved, or it's about a page and a half that went around. Should stay near the microphone. And so I thought it would be good if we could talk about that first, the scope of work, since regardless of what option we choose, we really need to get that finalized. And I wanted to see if everyone received it, first of all, and if they have any comments.
Madam Chairman?
Yes.
I did receive it, and this is my understanding is what the first IRC used. And I would endorse what was done before. I think the first IRC faced this issue, and this was the solution they came up with, hiring outside counsel, hiring dual outside counsel, a Republican and a Democrat. As much as we've enjoyed the services of the Attorney General's office, as was mentioned earlier, that position, these lawyers, in a way, serve at the pleasure of the Attorney General, who heads the department. And that's a partisan political office, and I think that the provision of the Constitution that breathes life into this commission mentions that we are to be independent, to be fair, and to be politically balanced. And to do that, I think we're better served by hiring outside counsel. I think that solves part of the problem. I don't think it solves the entire problem, because any lawyer we may look to hire, we're going to be looking for someone who has experience in the political area, in election law, in campaign finance law, redistricting issues. Inevitably, there's going to be some political charge to them one way or another. And we don't want to get ourselves in a position where whoever we do retain, if we go that route, where we've somehow damaged our independence in some way. Another concern is, the attorney-client relationship is going to be important for us. That's a relationship that's built on trust, on mutual respect. There needs to be a rapport there. And I think if any member of this commission doesn't feel like whatever counsel we retain, if we were to just hire a single counsel, hoping to strike some sort of balance, they're not being listened to if all bases aren't being covered. I think that damages and undermines that relationship a little bit, and it doesn't look good in terms of public perception. So I think with respect to what was prepared for the last IRC, I think there needs to be some minor updating into some citations as to what we're looking for. And I did have a question for council in terms of, or perhaps for the Department of Administration. There is a call out in there we're looking for council to serve us and bill us presumably on an hourly basis. And I don't know if we're locked into receiving services on an hourly basis. We might not want to tie our hands that way and look for more creative options. So I would have that question to be addressed, hopefully. But otherwise, I think we should go with we should look to outside counsel. I think it serves the interest of independence and fairness, political balance, and so we should go with what the first IRC did. So I would endorse what had been circulated to all of us previously in terms of a description of work.
Okay. Yeah, this statement of work, regardless of whatever path we choose, we've got to get this kind of finalized so that we can, it's kind of like the PDQ for the HR position. We got to get this going in order to get the RFP out, if that's the direction we choose. And even if we stick with AG council, it's good to have the statement of work defined so that they understand what it is we want to achieve and want them to do. So if we could, it sounds like Mr. Freeman is okay, except for it sounds like there might be some updating with regards to some of the statutes. Any other comments on this statement of work draft?
Madam Chair, I had a number of comments on the draft. I appreciate Mr. Freeman's perspective. I haven't reached a conclusion yet about who or how who our legal counsel should be or how it should be set up. And my perspective is that we should seek applications from qualified counsel and then address the issue that Mr. Freeman has raised. And that may ultimately be exactly what we need to do. But I do feel reluctant to, from the get-go, build into our process the assumption that we have to have within the commission a Republican lawyer and a Democratic lawyer. And the reason for that, I think, is because as a lawyer, the law is not partisan. The law is not Democratic law or Republican law. The law is the law. And I understand that there are different ways to interpret the law in order to achieve different direct objectives, and that this may not work. But ideally, it seems to me, given that we are Republicans, Democrats, and an independent, that it would make sense to have a lawyer or a law firm who represents the ARRC, all five of us, and tells us what the implications of the law are from each of our perspectives, whether it be Republican, Democrat, or independent. Now, ultimately, that may simply not be workable, but my thought would be to seek proposals from qualified lawyers and to ask them to tell us whether their background and experience has been with one party or another, or whether they would propose to represent us on a nonpartisan basis, and see what we get, and then proceed from there. So I had marked, I think we're a little different from the legislature. We're a much smaller body, and I understand the legislature has Democratic and Republican counsel. And again, that may be what we actually absolutely need to do. It's also true that the logical conclusion of the argument is we need three lawyers because we also need an independent lawyer. And that's circular, because if we could find that lawyer, then we would only need one lawyer, because we would have an independent lawyer. So my point is that I would like to approach this in the other way, to seek proposals from the most qualified lawyers that we can find. I think some of this, I think a lot of what they did last time is very good. I think some of it is a little too particular. I don't think we absolutely have to have counsel who has all of these qualifications. I think many of these things are important, and there are a couple things on here some things that need to be on here that aren't, such as knowledge of Arizona law and the pertinent case law. But I'd like to see who's out there and how they respond to us and how they respond to questions about the kinds of issues that Mr. Freeman has raised and the kinds of issues that I'm raising, and then make the decision rather than deciding at the front end, we're not going to use these people and we're not even going to inquire about this possibility. We're going to do this and potentially limit our options. So having said that, I had marked this up with some thoughts, and I don't know the best way to make those available to my other commissioners in compliance with the law.
Well, I would prefer to, if we could, get through this document today, this statement of work. And that's not to say we're going to make the decision today on which path we're going to choose. It's more to get the statement of work finalized so that then we can go out to these three different pathways and, figure out what do we want to do. Do we want to stick with the AG list? Do we want to give this to the AG office, see if they want to respond to us? Do we want to create our own RFP and go off the list, so to speak? So what I would really like to do, if we could, is finalize the statement of work document and agree upon what we want to put out to people.
Well, Madam Chair, following up on that, then I would suggest that in lieu of saying in paragraph 1.1, third line, one Republican and one Democrat, that the line read, counsel to provide legal representation to the ARRC on an hourly basis. And that we then add under specific requirements, new section or sections following the format that we have here, something to the effect that we would ask whether the lawyers have previously represented public or private entities in connection with the redistricting process. And if so, whether in the capacity as a Democrat, Republican, or on a nonpartisan basis. And then as number 4.6, whether the lawyer would seek to represent the ARC as a Democrat, a Republican, or on a nonpartisan basis.
Okay. And I'm sorry, before we leave Ms. McNulty's comments, you had mentioned, I think, that the qualifications, you didn't feel that necessarily all of these are necessarily required. Are they more like a preferred
Well, I thought about
opinion? Or
I thought about saying that the following qualifications would be important to consideration of a candidate. I'm not sure they're all essential, and some of them I think are a couple things that I thought about removing were in 3.1.2. There's a reference in the second line to the nomination process, and I'm not sure that has a bearing on what we're doing. In 3.1.3, the last phrase, an experience in successfully submitting such request to the U.S. Department of Justice, given that there are only opportunities to do that once every, decade, perhaps. I'm not sure someone couldn't represent us well without having that. 3.1.5, experience in representing state agencies, boards, and commissions. I think that's a little redundant with 3.1.1. I think a lot of the people that know a lot about public records law don't necessarily represent state agencies. They actually represent private firms that follow state agencies, or they represent public interest groups. So I'd like to see in 3.1.5, instead of this, a statement that whoever we hire would know Arizona law applicable to the redistricting process, including our constitutional provision and the pertinent case law. And then my last thought was in 3.1.6, experience in federal court litigation involving constitutional or federal statutory issues. I think that is probably important, but I'm not sure that it has to be someone who, has been involved in multi-party document-intensive cases, which kind of sounds like we're setting ourselves up for that. My last two comments, as I'm talking, I might as well finish. I don't think there's any compensation information in here, and maybe that's handled separately in the same way as the ED would be handled, and also a deadline for, also the deadline issue that we talked about.
Okay. Any other comments on this scope, the statement of work? Yes,
Yeah,
Mr. Freeman?
And I appreciate Commissioners McNulty's comments, and I think a lot of them, I agree with you, can be solved by making it clear that this isn't the sine qua non of what we need in terms of an applicant. These are preferred qualities, so we need to make that clear. I think, I agree with you that we should add a provision on familiarity with the Arizona law with respect to what we're doing in this commission and the case law that flowed from the first IRC. I think I don't have a problem with having a preference for someone who has some experience in multi-party litigation and document-intensive cases. That, to me, that would be a plus for us, because we could find ourselves in a situation potentially where, if not, where lots of documents, perhaps lots of data to crunch. I think with respect to 3.13, the Voting Rights Act has been amended in the last 10 years. We probably want to update the citation. This is not a big point, but to sections, reference sections 1971 through 1973C, 2006. I think we probably want someone also, and this I'm referring to 3.16, to have experience in state and federal court litigation. Probably be advantageous for us. Going back up to Section 2 on background, I just noticed there appears to be a typo that's carried through. The provision of the Constitution that authorizes us to hire outside counsel, it's sections 19 and 20. It looks like 19 and 2, which I don't think is quite right. But as for purpose, I don't think having the statement that we're looking for one Democrat and one Republican ties our hands necessarily. And I don't think it ties our hands in any way. I still think that should be in there, and I guess it's because I still think that's ultimately what we're going to have to do. I suppose once we get the applications and the responses to the RFP, I still don't think that we're not tying our hands to necessarily hire one or the other, but I would prefer to have that language in there at this point. And I guess one last point, going to Section 4.4, we're in essence asking for references there, and I would put in that last line, co-counsel and opposing counsel. Sometimes it's much more beneficial to talk to the opponents of the lawyers and get their thoughts than perhaps allied co-counsel. And the wording there gives them the option, I think, of providing us one or the other.
Okay. Thank you for your comments. Any other comments on the statement of work as written and amended so far?
No, but Madam Chair, so what happens with both of the these requests for changes made by both commissioners? How do you mesh that together?
Yeah, it's a good question. I would hope that we could actually agree on a statement of work today, if during this meeting, if we can. And then what would happen is, I don't think because of open meeting law, I can actually synthesize the comments myself. I think it probably should be done by our interim executive director or someone at ADOA that's going to be working with us on the RFP process.
That'd be best.
Okay. Yes, so do we want to have any other discussion just about the language that's in this statement of work?
Well, go ahead.
No, Madam Chair, I know we want to get this out, we need to get this out, get moving, but we're also going to be talking about our consultants as well, and we don't have a working draft on that, at least that I'm aware of at this point. You know, we may be faced with synthesizing this and the draft on the consultants and coming back perhaps sooner than we had originally thought, at least as of 30 minutes ago.
Yeah, I was thinking, though, that in a way, I think it would be great to have legal counsel on board in order to help us make that decision on the other consultative support, just because they will have, we hope, experience in redistricting law and could help us make the right choice on those consultants. So in a way, I kind of feel like legal counsel is pretty important to get on board even before the other consultative support.
Madam
Any
Chair,
thoughts?
I think that you've got several things that you've tried to roll into one discussion point here, and I want to see if I can cull this down. You've outlined 3 separate options for choosing counsel.
Right.
Then you've also outlined by discussion points between Commissioners Freeman and McNulty that there are 2 schools of thought regarding purpose, and then there is the general qualification component of what the expectations of the legal counsel would be. All of those have got a lot of teeth to each one of them. I've spent an enormous amount of time, I guess must have too much time on my hands, reading minutes and studying what the previous commission went through. And when it comes to purpose, became very clear to me that the decision that they made was the correct one as the duration of the commission went forward. In purposes of qualifications, I am ready, willing, and able to defer that to the 2 legal minds on this commission to use judgment to bring forward best practices for this type of position, along with counsel with the current AG representative to give us guidance on what the expectations for an RFP would be. In all deference to your statement, Commissioner McNulty, I have never, in my 30 years of business practice, not found an attorney that doesn't have a political position and a political leaning, even if they make a statement that they don't. And I get very troubled in thinking that we could try to find an individual that would be able to have that neutral position. And I think that the other commission in that analysis determined that it was troubling for them to try to find one as well. Although the view of it from an altruistic sense might be good, I think that in looking at the results that took place and the success that they had out of having separate legal counsel was smart and prudent. So from my perspective, the purpose as crafted under 1.1 still I'm most comfortable with. In regards to the AG's office, the AG's the current, I agree with Commissioner Freeman regarding the list that was provided to us that currently are in the pre-approved list. There were 84 pages plus 7 in a supplemental and 21 in a second supplemental. I don't know whether or not from the legal profession that covers all law firms that are most qualified, because the qualifications, it appears to me, are being adjusted right now, and I wouldn't know that. So I don't know whether or not from the DOA's perspective, whether or not that limits us to potentially someone that has a higher level of qualifications because the qualifications haven't been finally crafted from that list, or whether or not that speeds up a process. So if I may ask the question, of the DOA. If going to a general RFP to outside counsel, will that delay the process of acquisition?
Jean Clark, the State Procurement Administrator with DOA. Yes. I mean, having an existing contract that the Attorney General's office has in place that already has the defined contract terms, the payment terms, things like that identified, basically upon choosing, using your scope of work and then interviewing off of that listing, you could then effectuate and be able to start utilizing those services as soon as you made a decision. So you could do that, you know, as fast as you wished within a couple weeks, probably. You have to, when you're looking at that list, as you said, and I'm not the expert, you knowing your qualifications of what you're looking for, need to make sure that you're only targeting those firms that were awarded for that specialty, you know, of law. So it's not all 85, you know, 84 firms that you would be considering. You have to whittle
84
that
pages
down.
of firms.
Yeah, right. You'd have to whittle that down to which firms really, you know, are focusing on the area of expertise that you're looking for and the qualifications you've identified. By far, for us to issue, you know, an RFP, which we are more than willing to assist you with, will take more time. I mean, it's probably roughly, I mean, in a rush process, it's probably at least 8 weeks, more like 10 weeks, for us to be able to, you know, advertise and issue and negotiate, and your time for evaluation and things.
May I ask another question of that
course.
same? How can one process a DOA be expedited to a day and another process be expedited to 8 to 10 weeks?
Well, because of basically when we consider the procurement code, right, you need to finalize your scope of work, which you're doing. We need to then finalize the RFP, which some
Right.
of the decisions you're making on the scope of work and the language that would be in the RFP, the contract terms need to be discussed and agreed to, along with how do you want to price it. So we need time to be able to put that together. Then it needs to be issued out to the community, has to be advertised in the paper, has to be published for at least 14 days, legally by statute. Proposals are submitted, then you're going to want to review all those proposals, evaluate, have meetings, discuss the evaluations of those offers, and then, you know, there can be discussions and then contract award. So it's roughly, you know, if you look at it, it's roughly about an 8-week process.
Madam Chair?
Yes.
My understanding is that the commission does not fall under the procurement guidelines, and that we may adjust the guidelines as we see fit.
I can't speak, I mean, what we have been identified, and that might be more of a question for Mr. Mons, but it's my understanding, and previously, because the State Procurement Office did handle the procurements in the past, that we have delegated the commission procurement authority. They are required to follow still procurement rules, and so then are subject to the procurement code.
Madam Chair?
Can we get advice from council
Please.
on that?
Well, that would definitely be something I'd have to research, because that's a very interesting issue. Sort of the constitutional relationships of the procurement code. I have to take a look at that.
Madam Chair, I agree with Mr. Sturts. My understanding is that pursuant to the constitutional provision, we have been authorized to do our own procurement, and that we would not be subject to the procurement code. I also think that much of this is, we will drive the time frame for much of this, and that if we get on it, it really doesn't matter whether it's someone who's on the list or not on the list. We're going to have to go through the same process of interviews and teasing out whether they're folks we can work with, if we do have counsel from both parties, whether they're folks who can work with one another, whether we can work as a team, whether our independent member is going to feel comfortable with the representation that we're selecting, and all of those things, and that's going to be relevant to whoever it is, and this is quite an important decision.
Yeah, I think you've,
I agree.
yeah.
Okay. Any other advice from council on this, or thoughts that you'd suggest?
I'll take a look at it right away. I was just looking at your constitutional provision. It does have a clause in there about fiscal oversight from DOA. Then you'll have procurement authority. So I'll need to take a look at that and talk to one of our procurement experts on that take, and I can get back to you with our thoughts on independent procurement authority for the commission.
Okay. Thank you. I think that even if we have the independent procurement authority to move forward on our own, we still need to finalize a statement of work. And I'm wondering if this is something we can accomplish today based upon the comments that have been provided so far by Commissioners Freeman and McNulty. Or if, how people are feeling about proceeding. Any thoughts?
Madam Chair, I have two thoughts. First, I'm not going to belabor the point, but I do think that by including one Republican and one Democrat in our purpose statement, that we are discouraging anyone from applying to represent the entire commission, and we are essentially foregoing that option. Having said that, if that's what the group is inclined to do, I'd be willing to work with Mr. Freeman as a subcommittee of sorts to, hammer out the language of the draft and bring it back next time if that makes sense.
Madam Chairman, I'd be happy to do that, and I think one thing that needs to be stated is the council who is retained by us, we're all going to decide that, whether Republican and Democrat, and they have to represent the entire commission at all times. They're not representing just two commissioners. That, I just wanted to say that. And I think the first IRC, you mentioned the attorneys working together well. I think that's an important thing for us to look into, and I think there was a good relationship last time. I'm not aware of any material disagreement at all, and the last council, I think, was well-served, or the last commission was well-served. So if that's something we can do, work as a subcommittee and hammer out some language, I'm happy to do it.
I believe it is. I think legally, are there allowed to be subcommittees of the commission that did this?
Probably, but it may, since there's not a quorum, it might be easier if they just did it informally, because a subcommittee is held to the same open meeting law requirements
So,
as a commission, so you'd have to notice and have minutes and everything for every time you two talked
So-
about it. So it
Let the
might be.
record reflect, I did not say the word subcommittee.
Right, so if it's not a formal subcommittee, the two commissioners, not being a quorum, can sort of talk about it and get something together for the commission to consider.
So just so I'm clear, we can then exchange drafts, and then when we get to some agreement, we can send it to our
Executive director.
interim DED and then publish it to the entire commission.
Is that correct, accurate? Okay. Great. I would like to also just add to this statement of work that I think it's going to be really important that we try to be as cost-effective as we can be, just generally across the board. And if there's a way for these, if we do an RFP, for instance, if there's a way for counsel or attorneys to provide ways of showing us how they're being cost-effective, for instance, and not trying to be onerous, but just to possibly assign lesser less complex tasks to lesser counsel, so to speak, the associate counsel, for instance, as opposed to using the top gun for dealing with something to do with open meeting law. And I don't know if there's a way to incorporate that into the statement of work, or if that's just assumed that people would respond in such a way, but I just wanted to raise that issue.
I think, and Madam Chairman, before we leave that, the question, perhaps it's for council, are we required to hire counsel on an hourly basis? Can the attorneys responding to our request propose alternate billing arrangements to the commission?
I'm not aware of any restriction in the Constitution on your formation for that, but if the procurement code has a different limitation, Jean might be able to answer that.
No, there is not any limitation. The only limitation on the procurement code is that you can take the pricing, be it if you wish it to be at a retainer or you wish it hourly. Pricing can be a factor, but it can't be the sole determining factor when we're, soliciting for, legal counsel services. So no, we can look at different methods on how you would wish to have the solicitation priced.
Madam Chair?
Yes.
A question of counsel for us, also asking, in subsection 19 of the, where it refers to this issue, is there a definition of fiscal oversight?
No, that's what I was going to look into because it's an interesting term.
Fiscal oversight is, from a layman's point of view, means oversight of the fiscal operations, and not, it states clearly to me that, that the commission has standing in procurement contracting authority, and therefore we can work aggressively to bring counsel on staff outside of normal procedural requirements that may be currently in place at DOA. But I'd like to get confirmation of that, please.
That's what I was going to look at. First, there's a question about DOA's role, and then there's a question if the procurement code applies at all to the commission, which I think is a pretty significant question. I'll have to take a look at that.
McNulty?
Madam Chair, I don't think the question you're asking is whether the procurement code applies at all. I think it's simply asking whether we can retain counsel without following the list, and whether fiscal oversight would be defined as Mr. Sturts just defined it.
Well, you can clearly retain counsel that's not on that approved list. The question is going to be, when you try to retain counsel not on that list, are you going to have to follow the RFP process set forth in the procurement code, which is generally applicable to all state agencies, whether there's an exemption for the commission? So that would mean that you wouldn't have to go through that posting process, or, because I understand the desires for something quick. Or maybe I'm misunderstanding Mr. Sturts' question.
No, it's just clear that the commission shall have procurement and contracting authority,
Right.
and may hire staff and consultants for the purposes of this section, including legal representation. That's
I'm going to be looking at that and trying to research that.
what you guys do. So,
Any other comments?
I wasn't suggesting that we not post and have an RFP.
yeah,
Okay.
I know.
All right.
Okay. So in terms of moving forward on this, it sounds like our two legal members of the commission are going to look at this draft and statement of work and take into consideration what we all discussed today, and provide their feedback to Megan Darien for synthesis and completion into one document. And then council is also going to be looking into what kind of authority we have in order to proceed with an RFP of some kind, if that's the path that we end up choosing. I really would like to thank Jean Clark for coming today. She's been very helpful outside of this meeting too, in terms of advising me on some things associated with the RFP process, and we appreciate her time today. Does anyone have any other questions regarding the RFP process while she's here?
Thank you.
Okay. And then the next item that's part of this agenda item is other consultative support. And we have not been able to locate yet the RFP that was used for the mapping consultant last time. And they're still looking for it. State Procurement Office had some system changes in the past 10 years, and so they're digging through their old systems to see if they can find any information on that RFP. Yes?
We did look, and we do not have any of that information because of the timing, and the retention, so.
Okay. And I've also checked to see if the people who have looked into the boxes from the previous commission have been able to locate anything with regards to RFP, and they have not. So I'm not sure yet. We know the name of the vendor that was used, but we thought it would be helpful to be able to look at that statement of work to see, how it was crafted and whether we want to proceed similarly or not. So any thoughts on locating the RFP? Does anyone have any information with regards to that?
Madam Chairman?
Yes, Mr. Freeman?
Have we asked the vendor?
No, we have not. So that is something that can be done. We can just contact them directly. I can. Okay. But it is an important thing that we also want to keep on the agenda going forward is making some progress on that consultative support. And And it may be that legal counsel should be retained before. Does anyone have thoughts on that? In fact, the order of whether the legal counsel should be in place before we're working on the consultatives
Madam Chairman.
RFP? Yes, Mr. Freeman.
I don't think we need legal counsel. That, to me, doesn't strike me as something falling within the purview of legal advice.
Okay.
This is a core function of this commission. I think we can all make our own independent judgment on that. I'm not saying I wouldn't like to hear from lawyers or counsel on it, but I think that's something we can start doing now. If we
Okay.
can, and might I suggest, if we could get the RFP, let's say hypothetically, the vendor has it handy and can shoot it to us, then perhaps we form another unofficial subcommittee with, and I'll volunteer Commissioner Sturts and Commissioner Herrera
Sure.
to put together at least a first draft of what that should look like.
Great.
Said volunteer or voluntold? Madam Chair?
Yes, Mr. Stearns.
I think that as, and I think that makes perfect sense. Our purview should be that we should be looking for the best, the brightest, and the most competent that will be bringing forward the most comprehensive and fairest and most independent view of our task at hand with the highest level of competence available to us within the nature of this overwhelming task. And in doing independent research, there are several extraordinary companies that have tailored their skills across the nation to do this work in the states that have independent redistricting commissions. So I'm looking forward to crafting that sort of language to get out a concise, defined, and we'll, unless Mr. Herrera disagrees, we can bring forward that for distribution review prior to the next meeting.
Madam Chair?
Yes.
Yeah, I don't
Mr.
disagree at all with your comments. The only issue, and I raised this last time, is that we should give preference to Arizona firms. Anytime we're spending Arizona money, I think we should try to do our best to keep the money in Arizona. So that would be something that I think we should include in that RFP. Not only that, but also the issue with what's going on in California with, there was a organization that applied to be the consultant, and one of the requirements from the California Commission was to ask for the organization to disclose their donors, and one of them chose not to, and they were disqualified. So I want to make sure that we get as much detail from the companies that are applying, so we don't have to go through that, mess, I guess.
Yeah,
Mr. Sturts.
Thank you. Commissioner Herrera, I will, the concept of bringing forward disclosure falls perfectly with the format of the first word we are the Arizona Independent Redistricting Commission. But I highly disagree that we would give any preference, and I don't even believe that it would be legal to give preference to a state of Arizona contractor. However, as much as I may agree with the concept, we are looking for the best and the brightest.
Correct.
And by having preference, that would mean that if we would have, that means that would be potentially excluding the best and the brightest. And I don't think that that's what your intent is.
May I respond?
Yes, Mr.
Yeah, no, my intent was not to do that, but I think we have every right to, as we do with any job description, to add certain requirements or recommendations. It's not a requirement, but I would say it would be a highly preferred, because I think we are spending the Arizona taxpayers' money, and we should take that into consideration, that the money stay in Arizona. The best and the brightest should be the first thing that I'm looking at, we should all be looking at. But I think hiring people, the best and the brightest in Arizona, there's nothing wrong with that. And I think our taxpayers, would probably want us to do that for the money to stay in Arizona. And but again, best and the brightest is the most important thing. But having the money stay in Arizona is not too far behind.
Okay, Mr. Freeman?
Madam Chair, I do have concerns about inserting any sort of artificial criteria that might tilt the scales with this RFP. I think we want to keep the language broad so we can cast the biggest net, and then we can make those judgments. There is some concern about, in my mind, legally, in terms of overt direct discrimination against people from other states and companies from other states. But it also, we don't want to get ourselves in a position, I think, where we've inserted a criteria to tilt the scales and limit us or force us to pick. And that was some of the concern, I think, that came up with the California Independent Commission, was that they inserted a criteria, at least some have said, alleged, that was designed to pick the consultant. I don't want to do that here. I don't know what the universe we're dealing with in terms of Arizona consultants. Is it 3? Is it only 2? Is it only 1? And are we inserting a criteria that's going to force us or heavily tilt the scales into picking that person? It may not be a person who we would feel would be completely independent. So I think hopefully the two of you can hash something out or propose a draft or drafts, and we'll get back together and we'll talk about it more, I guess.
Sounds good. Any other comments? Ms. McNulty?
I would only comment that I have the same, some of the same concerns about council, and when we broadcast, when we post, that we cast a broad net.
Okay.
And see what we get, and then evaluate who works best.
Great. All right, so,
Madam Chairman.
oh, I'm sorry, Jean? No, please.
Madam Chair, Commissioners, I did want to indicate that currently, although the question is, do you fall underneath the procurement code or not? But statutorily, we do not have any legal authority for local preference laws. We do have for small businesses less than $50,000, but there is no local Arizona preference law statutory authority at this point. There is a bill going through the legislature right now, but that has not been determined yet. Secondly, if it would be helpful, if there are any other states that you feel might be, have gone through this process that you might be interested in, like their RFPs on this on this topic of things, if there's particular ones you'd like us to reach out to, I could try to reach out to my counterparts in the other states
Sure,
to
that
see
makes
what
sense.
type of RFPs and scopes of work we have for this type of service too. So I just offer that as an option.
I appreciate that. I think that would be wonderful to have.
Yeah.
So if you could proceed. Thank you. And thanks for the clarification, too, regarding the local authority. Any other comments before we move on? So thank you. I appreciate the commissioners, both for legal counsel and for the other consultative support that you two groups are going to be getting together and working this out. So I appreciate that. I want to be sensitive to the time. It's 3:15. Do we need to do a recess for a short break?
I would love a bathroom break.
Okay. Do I need a motion to recess? I can just recess.
No, but just state a specific time, how long it's going to be.
Okay, yes. We'll take a brief recess, 10 minutes, if everyone could be back at 3:25.
By that clock?
On that clock. It's already 3:25. Yeah, no, that one's not right. That one is.
I just reset my watch. Cast a